When we picture a murder investigation, we usually imagine something visceral, a crime scene tape, flashing lights, a weapon left in an alley. This chart shows the apparent methods of killing for recorded homicides in England and Wales. Notice the massive spike at the top, sharp instruments. That is the gritty, everyday reality of most unlawful killings. And if you look at this timeline of the overall homicide rate, it remains relatively flat year over year. The total numbers only jump significantly during major macro-level tragedies, like the London bombings in 2005 or the terror attacks in 2017. These statistics capture the bulk of the criminal docket, but the most significant legal stress tests occur far from the streets, inside the hospital room. English homicide law operates like a rigid engineering system built on incredibly strict definitions. To understand how that system actually works, we must see what happens when its structural boundaries confront the biological extremes of modern medicine. The foundation of this system was laid in the 17th century by Sir Edward Coke. His classic common law definition of murder states that a person commits the crime when they unlawfully killeth any reasonable creature in rerum natura, with malice aforethought. That definition forms the actus reus, or the guilty physical act required to commit the crime. It hinges entirely on the phrase, a reasonable creature in being. You cannot legally murder an entity the law does not recognize as a living person. This flowchart shows how the legal framework categorizes all forms of unlawful killing. To secure a murder conviction, the prosecution must trace a specific path, an unlawful killing that is intentional with no partial defense. If met, the result is murder. So, how does a binary 400-year-old framework adapt when medical technology blurs the exact moment a human being begins or ends? We start our stress test at the very beginning of life. When does a fetus legally become a reasonable creature in being, capable of being murdered? The courts faced this exact question in the tragic case of Attorney General's Reference Number 3 of 1994. A pregnant woman was stabbed, causing her to give birth prematurely. The baby survived the birth, but died 121 days later from complications caused by the premature delivery. The prosecution tried to build a murder case using transferred malice, a doctrine where the mens rea, or guilty mind, intended for one victim can be legally transferred to another. They argued the attacker's intent to cause serious harm to the mother transferred to the fetus and then to the born child. But the House of Lords rejected this. At the time of the stabbing, the fetus did not legally exist as a person in the eyes of the law. Because a double transfer of intent to a non-legal entity is logically impossible, the murder charge failed. However, the attacker was still convicted of manslaughter. The court ruled he committed a dangerous, unlawful act against the mother that ultimately caused the death of a live-born child. English law establishes a hard, mechanical line here. An entity only gains the protection of the Homicide Act upon being wholly expelled from the mother with an independent circulation. If we shift the timeline to the opposite extreme, we encounter a different problem. What happens when a person is biologically alive, but their life is sustained entirely by artificial machinery? End-of-life jurisprudence in English law is governed by a vital structural binary, the strict legal difference between a positive act and an omission. This was tested in the landmark case of Airedale NHS Trust versus Bland. Anthony Bland was a patient trapped in a persistent vegetative state, or PVS. PVS is a medical condition where a patient is biologically awake but completely unaware, with no hope of recovery. The court used careful legal engineering to resolve the issue. Doctors operate under a duty of care to their patients. But if ongoing life-sustaining treatment is deemed utterly futile and no longer in the patient's best interests, that legal duty ceases to exist. Because the doctor's duty to treat had ended, the decision to withdraw his artificial feeding tube was legally classified as an omission, a failure to act, rather than a positive act of killing. By defining the withdrawal of life support as a legally neutral absence of action, the court allowed the patient to die without classifying the doctor's behavior as murder. That logic only holds up if the doctors are letting a patient die. When death is brought about by a proactive step, the law takes an absolute, uncompromising stance against mercy killings. In the Inglis case, a mother intentionally administered a lethal dose of heroin to her severely paralyzed son. She acted out of pure compassion to end his suffering, but the law recognizes no defense for this. The intent to kill was present, so the mens rea for murder was met, resulting in a mandatory life sentence. Even when a victim actively begs for death, the law remains inflexible. Anyone who commits a positive act to help another person end their life violates the Suicide Act 1961, which carries a penalty of up to 14 years in prison. This rigid framework devastated Diane Pretty. She was terminally ill with motor neuron disease, a rapidly progressive neurological condition that destroys the body's muscle control. She wanted to die with dignity at home, but she needed her husband's physical assistance to do so. She asked the Director of Public Prosecutions to guarantee her husband wouldn't face prosecution if he helped her. The House of Lords refused to grant him immunity. They reaffirmed that a patient's consent cannot authorize a second party to commit a positive act to end their life. The rule is absolute. If you commit a positive act that accelerates death, no matter the mercy and no matter the consent, you have crossed the mechanical boundary into unlawful killing. This uncompromising rigidity inevitably triggered a collision between ancient common law and the European Convention on Human Rights, or ECHR. The ECHR is an international treaty designed to protect basic civil and political freedoms across Europe. In later appeals, such as the Nicholson case, severely paralyzed applicants argued that forcing them to endure undignified suffering violated their Article 8 rights. Article 8 is the specific section of the ECHR that guarantees everyone the right to respect for their private and family life. This put the Supreme Court in a painful dilemma. They openly acknowledge that the blanket ban on assisted suicide does in fact interfere with a person's Article 8 rights to personal autonomy. But the court ultimately justified upholding the law by weighing that autonomy against the state's overriding obligation to protect vulnerable populations. They argued that legalizing assisted suicide could create dangerous pressure on the sick and elderly to end their lives prematurely. The courts eventually reached an uneasy compromise in a case involving an MS sufferer named Debbie Purdy. Rather than striking down the law, they ordered the Director of Public Prosecutions, the head of the Criminal Prosecution Service, to publish specific guidelines outlining exactly when they will actually choose to prosecute these crimes. Parliament and the courts refused to dismantle the structural definition of the crime. Instead, they shift the burden of compassion away from the statute books and onto the discretionary power of the prosecutor. The English law of homicide does not operate on gradients of morality. It acts as a rigid sorting mechanism. Looking at the flowchart, we see how these edge cases map onto the legal architecture. Fetal injury is caught by involuntary manslaughter. Mercy killing funnels inexorably down the intentional path toward murder. But withdrawing life support bypasses the chart entirely through the omission loophole. A defendant's fate, life in prison or absolute legal immunity, depends entirely on which mechanical pathway their actions trigger. In his judgment on the Pretty case, Lord Steyne observed just how narrow the exceptions to these rules truly are, noting, "These are at present the only inroads on the sanctity of life principle in English law." But medical science will only continue to advance, further blurring the biological realities of birth, consciousness, and death. The fixed 17th century gate defining the actus reus is struggling to accommodate these highly complex modern realities. We are left with an uneasy truce. The law remains absolutely rigid in statute, but quietly bends in application through prosecutorial guidelines. Defining a reasonable creature in being is a high-stakes negotiation between 17th century common law, modern clinical science, and human rights.